They thought I was finished. They sat across from me in that courtroom, my son, his wife, and their lawyer in a $3,000 suit, and they smiled like men who had already won. Maybe I looked the part. 67 years old, worn hands, a sport coat I'd had since George W. Bush was in office. No attorney sitting beside me, just me and a manila folder on the table. My son, my own son, leaned over and whispered something to his wife. She covered her mouth. They both laughed. I looked down at the folder. I had spent 41 years building something. They spent 3 years figuring out how to take it. But they forgot one thing. I'm a patient man. My name is Clifford, and I want to tell you something before I start. I am not a dramatic person. I have never in my life enjoyed conflict. I grew up in Macon, Georgia, the son of a man who fixed appliances for a living and a mother who taught second grade for 30 years. We were not wealthy. We were not powerful. But we understood one thing clearly. You earn what you keep, and you keep what you earn. I spent my career as a civil engineer. Roads, bridges, drainage systems, quiet work, invisible work, mostly, the kind of thing nobody notices until it breaks. I retired at 63 with a pension, a modest investment portfolio, and a piece of land outside of Asheville, North Carolina that I had bought in 1994 for reasons even I couldn't fully explain at the time. 42 acres, mostly timber, a creek running through the back of it. My wife, Elaine, passed in 2019, pancreatic cancer, 11 weeks from diagnosis to the end. There are things I still can't talk about from that period. We had been married 38 years. After she died, I had 2 children left in this world. My daughter, who lives in Portland and calls me every Sunday without fail. I won't bring her into this story because she has nothing to do with what happened and deserves her privacy. And my son, I'll call him my son throughout this. That's what he is. That's what he will always be, even now. I raised him. I coached his little league team. I drove him to college in a rented truck and cried on the highway home. Whatever came later doesn't change the 30 years before it. His wife, I'll call my daughter-in-law. She came into the family 8 years ago. Polished, organized, the kind of woman who sends handwritten thank you notes and remembers your coffee order. I liked her. I trusted her. That was my first mistake. Not trusting her, exactly, but trusting the version of herself she chose to show me. They live in Charlotte, nice house, 2 kids in private school, a lifestyle that required more income than either of their salaries could reasonably support. I knew this. I chose not to say anything. Parents learn, eventually, when to speak and when to stay quiet. For 2 years after Elaine passed, my son called every week. He visited on holidays. He sat with me on the back porch and we watched the sun go down over the ridge and drank sweet tea and talked about baseball. I was grateful for that. I was so grateful I didn't notice what was happening right underneath it. It started with the power of attorney. He brought it up gently, the way you bring up something you've rehearsed. Said he'd been talking to a financial planner. Said it made sense at my age to have someone legally designated to manage my affairs if something happened to me. Completely reasonable. Completely standard. He had the paperwork already drawn up when he mentioned it. I should have paused. I should have taken that document to my own attorney and had it reviewed line by line. But I was 65, I was still grieving, and this was my son sitting across from me at my own kitchen table. I signed it. I want you to understand something. That document didn't give him control over everything immediately, but it gave him access, and access in the wrong hands is a door that never fully closes. Over the next several months, things began to shift in ways I can only describe as feeling like weather. You don't see a storm coming when you're standing inside the house. You just notice one day that it's darker than it should be. He started asking questions about the land. Casual questions at first. What was I planning to do with it? Had I thought about the tax implications of holding it in my name versus a trust? Did I know that timber properties in that county had been selling well? I told him I wasn't interested in selling. He nodded. He moved on. Then my daughter-in-law began joining the calls. She was warm as always, but now there was an agenda underneath the warmth. She started mentioning a developer she knew. She mentioned liquidity. She mentioned that property values were peaking and this might be the moment to act. I told her the same thing I told my son. I wasn't selling. Something changed after that. The calls became less frequent. The visits stopped. When I called my son, he answered, but the conversations were shorter. There was a distance in his voice I didn't recognize. I told myself he was busy. Told myself it was the kids, the mortgage, the pressures of middle age. I wanted very much to believe that. Then I got a letter from a bank I had never done business with. It was a statement. A home equity line of credit, opened in my name, against the Asheville property. The balance drawn was $340,000. I sat at my kitchen table for a long time with that letter in my hands. I'm going to tell you what it feels like to discover that your child is stolen from you. It doesn't feel like anger, not at first. It feels like the floor dropping out. It feels like every memory you have of that person suddenly becomes a question. Every dinner, every phone call, every moment of apparent love, you hold it up to the light and you wonder if it was real or if it was investment. If you were a father or a resource. I folded the letter, I put it in a drawer, and I called no one. That was the most important decision I made in this entire story. I did not call my son. I did not call the bank. I did not call a lawyer. Not yet, because I had spent 41 years as an engineer, and the first thing an engineer does when he finds a problem is understand its full scope before he touches anything. Over the next 3 weeks, I requested records. Bank records, property records, anything I was legally entitled to access. I drove to the county clerk's office in Buncombe County myself and sat at a public terminal for 4 hours, going through filings. What I found was organized and, in its own way, almost impressive. The HELOC was the beginning. My daughter-in-law, using the power of attorney I had signed, had also made 2 transfers from my investment accounts, smaller amounts, structured to stay below reporting thresholds. And they had begun a legal process I didn't initially recognize until I brought the paperwork home and read it twice. They were pursuing a conservatorship. If you don't know what that is, let me explain simply. A conservatorship is a court proceeding in which a judge determines that an individual is no longer capable of managing their own affairs, financially or personally, and appoints someone else to do it for them. It is a tool designed to protect vulnerable adults. In the right circumstances, it is a genuine mercy. In mine, it was a mechanism to hand legal control of my assets to my son. They had filed paperwork claiming that I showed signs of cognitive decline, that I had become forgetful, confused, unable to manage my finances. They had a letter from a physician, a man I had never met, supporting this assessment. My son was petitioning to become my conservator. I went to bed that night and I lay in the dark for a very long time. I thought about my father. He used to say that the worst thing a man can do is underestimate a problem. The second worst thing, he said, is let the problem know you found it. In the morning, I made one phone call to an elder law attorney in Asheville named Frances Okafor. She had been recommended to me by my doctor years before in a different context. I had simply kept the name. I told her everything. I told her about the HELOC, the transfers, the conservatorship filing, and the power of attorney. She was quiet for a moment after I finished. Then she said, "Mr. Bidiyan, Clifford, don't touch anything, don't move any money, don't confront anyone, and don't sign anything. Come to my office tomorrow morning." I did. What Francis explained to me over the next 2 hours changed how I understood my situation entirely. The conservatorship petition had been filed but not yet heard. I had time, not much, but some, to respond. In a conservatorship proceeding, the person being petitioned against has the right to appear before the judge and contest the filing. More importantly, I had the right to present evidence of my own cognitive competence. And, more importantly still, the fraudulent use of a power of attorney is a crime in the state of North Carolina. A serious one. She told me what I needed to gather. I told her I had already started. Over the following 6 weeks, Francis and I built something together. I underwent a full cognitive evaluation through a neuropsychologist at Mission Hospital, scored in the 94th percentile for my age group on every measure. I obtained my complete financial records, which Francis used to document every unauthorized transaction. We identified the physician who had written the letter supporting the conservatorship claim and discovered he was not licensed in North Carolina. His letter was fraudulent, and I did one more thing, on my own, that Francis did not ask me to do, but did not discourage. I had a security camera installed in my kitchen in 2020 after a break-in in the neighborhood. A small thing mounted near the smoke detector. I had forgotten it was there, honestly, until this situation began. I went back through 8 months of footage. It took me the better part of a week, watching in the evenings. What I found was 4 conversations between my son and my daughter-in-law, held in my kitchen while I was in another room. In those conversations, they discussed the HELOC, the account transfers, the conservatorship timeline, and, this is the part that still stops my breath when I think about it, what they planned to do with the proceeds of the land sale once they had conservatorship established. None of it was ambiguous. None of it was open to interpretation. I copied the footage to 2 external drives. I gave one to Francis. I put the other in a safe deposit box at a bank 30 miles from my house. The conservatorship hearing was scheduled for a Thursday in March. I want to tell you about the morning of that hearing because it matters. My daughter called the night before. She had heard something from my son. He had told her I was struggling, that the family was worried, that the hearing was about getting me proper support. She called me scared. I told her I was fine. I told her I loved her and that she should trust me and that she would understand everything soon. She said, "Daddy, you sound like yourself." I said, "I am myself." I wore a gray suit that morning, a good one. I had bought it for Elaine's memorial service and had not worn it since. I shined my shoes. I drove myself to the courthouse in Asheville and walked in alone because Francis had advised me that arriving without a visible legal team for as long as possible would give us a certain strategic advantage that I'll explain in a moment. My son and daughter-in-law were already in the courtroom when I arrived. They had 2 attorneys with them, a lead and an associate, both from a firm in Charlotte. Their whole presentation was polished, coordinated. My daughter-in-law wore a conservative blazer. My son had a fresh haircut. When I walked in alone, in my gray suit, my son's expression did something I will never forget. It relaxed. His shoulders came down half an inch. He thought my being alone meant I was unprepared. I sat at the respondent's table. I set my manila folder down. The folder contained nothing but a single photograph of Elaine and me at our 25th anniversary. I had put it there to keep myself calm, nothing more. Everything else was in Francis's files. The petitioner's attorney went first. He was good, organized, confident, spoke in the measured cadences of a man who had done this many times. He presented the physician's letter. He presented what he characterized as evidence of my financial confusion, transactions he claimed I had made irrationally. He told the judge, the Honorable Sandra Kellerman, that my son was acting out of love and concern, and that the conservatorship would ensure my safety and well-being in my remaining years. My remaining years. I wrote nothing down. I just listened. When he finished, Judge Kellerman looked at me. She asked if I was representing myself. I said, "No, Your Honor. My attorney will be here momentarily. She asked me to let you know she was parking." Frances walked in 40 seconds later, rolling a document case. She sat up quietly. She did not rush. Judge Kellerman gave her a moment to settle, then asked the petitioner's attorney if he had anything to add before the respondent's presentation. He said he did not. Frances stood up. She did not raise her voice. She did not raise her voice. She did not make speeches. She presented the neuropsychological evaluation first. My scores, my percentile rankings, the examining doctor's written conclusion that I showed no signs whatsoever of cognitive impairment. The petitioner's attorney objected that one evaluation was insufficient. Frances introduced a second evaluation, conducted independently by a different neuropsychologist, 2 weeks after the first, same results. She then presented the credentials, or rather the lack thereof, of the physician who had authored the letter supporting the conservatorship. He was not licensed in North Carolina. His letter, Frances told the judge, had been submitted to this court fraudulently. The attorney for my son objected. Judge Kellerman told him to sit down. Frances presented the financial documentation next. Not my confusion, their access. Every transaction conducted through the power of attorney, with dates, amounts, and the legal standard under which each one constituted a breach of fiduciary duty. Then she handed the bailiff a tablet. She had edited the footage carefully. 4 clips, totaling 11 minutes. No music, no narration, just my kitchen and 2 people talking about what they intended to do with my land and my money, and how the conservatorship was the key to making it possible. The courtroom was very quiet. My son's lead attorney stood and said something about the footage being obtained illegally. Frances explained patiently that North Carolina is a one-party consent state for audio recording and that Mr. Clifford, she nodded at me, was a resident of that home and a party to those conversations, by virtue of his presence in the adjoining room. The objection did not survive. Judge Kellerman watched all 11 minutes. She did not look up from the tablet once. When it ended, she set the tablet down on her desk. She looked at my son, then at my daughter-in-law, then at their attorneys. Then she looked at me. She said, "The petition for conservatorship is denied." She said it the way you close a door, firmly, finally, without drama. Then she referred the matter to the district attorney's office for criminal investigation. She used the words elder financial abuse and fraud upon this court. She said them clearly and let them sit in the room. My son's attorney asked about next steps for his clients. Judge Kellerman said his clients should consult with a criminal defense attorney. That was the last thing she said on the matter. I sat in the parking lot afterward for about 15 minutes before I started the car. I wasn't crying exactly. It was something else, a kind of pressure releasing that I hadn't realized I'd been carrying. The way a house settles in winter, that low groan in the walls. I had been holding something in since the morning I opened that bank letter, and sitting there in the parking lot, I finally let it go. Frances came out and knocked on my window. She asked if I was all right. I said I was. She told me what came next legally: the civil recovery claim, the criminal referral process, the revocation of the power of attorney, which she had already drafted. She said it in the calm, matter-of-fact way that good professionals deliver hard things, and I appreciated her for it. The criminal investigation took several months. I won't detail every step because this story is already long and the legal process in these matters tends to be slow and procedural in ways that don't make for good storytelling. What I will tell you is this: my son was charged with elder financial abuse and fraud. My daughter-in-law was charged with the same. The physician who authored the fraudulent letter was separately referred to the state medical board. The HELOC was unwound. The bank, once presented with Frances's documentation, cooperated fully. The transferred funds were the subject of a civil judgment that I eventually recovered, minus some attorney's fees. My son pleaded guilty to a reduced charge. He received probation and community service. and he's required to make restitution over 5 years. His wife received a similar arrangement. I think about what I want to say about my son, and I find that I don't have clean feelings to offer you. I don't hate him. I don't know if I'll ever fully understand what led a man I raised, a man I love, to look at his father's life and see only an obstacle between himself and comfort. Maybe it was the debt I didn't know about. Maybe it was his wife's pressure. Maybe it was something in him that was always there and I refused to see. What I know is that the land is still mine, 42 acres. The creek still runs through the back of it in the same direction it always has. I went out there in April, after everything was settled, and I walked the whole perimeter like I used to do with Elaine on 4 weekends. It took me 2 hours. My knees aren't what they were, but I made it all the way around. I want to say one more thing, because if you are watching this and you are getting older, and you have people in your life who manage your affairs or have access to your accounts or your property, please hear me. Get your own attorney to review any document before you sign it. Not a family member's attorney. Yours. A power of attorney is not inherently dangerous, but it is a significant legal instrument, and it deserves the same attention you would give to any contract you sign. Know your own financial accounts. Log in regularly. Set up alerts. If something appears that you did not authorize, do not confront anyone. Do not mention it. Call an elder law attorney and let them guide you. And keep your records. Keep your records for longer than you think you need to. I would not have been able to do what I did in that courtroom without the documentation I had been quietly building for 6 weeks. The evidence was there because I looked for it before anyone knew I was looking. I'm 67 years old. I live alone in a house in North Carolina with a dog named Chester and 42 acres of timber. I have no intention of selling to anyone. I still drink sweet tea on the back porch and watch the sun go down over the ridge. Some things they cannot take from you. I've had a lot of time to sit with what happened, not just the legal outcome, the part before it, the months when I knew something was wrong and chose to say nothing, to move quietly, to build my case like I used to build drainage systems, one careful layer at a time, invisible until it held. People ask me sometimes if I'm bitter. I understand why they ask. A man's own son, his own house, his own kitchen table used as a planning room for his own undoing. If there's a story built for bitterness, it might be that one. But here's what I actually feel, and I want to be honest about it, because I think it matters more than the legal details or the courtroom moment or any of the satisfying parts people tend to focus on. What I feel is responsible, not guilty, responsible. There is a difference. I signed the power of attorney without having it reviewed. I noticed the distance growing between my son and me and told myself it was just the pressures of his life. I wanted so much to believe that the warmth was real, that I didn't ask hard questions when the warmth started to have an agenda underneath it. I am not the villain of this story, but I am not entirely without a role in how it unfolded. That's the part nobody tells you about getting older. You think wisdom comes automatically, like a pension that vests at a certain age. It doesn't. Wisdom is just the name we give to the lessons we actually learned, as opposed to the ones we were handed and nodded at and set aside. I have been handed plenty of lessons about protecting myself financially. I nodded at all of them. I set them aside. What saved me, in the end, was not cleverness. It was discipline. The discipline to be still when every instinct said to confront. The discipline to gather evidence before drawing conclusions. The discipline Frances showed when she told me not to touch anything and I actually listened. Discipline is not exciting. It doesn't make for a dramatic moment. But it is the thing that makes the dramatic moment possible. I think about my son, and I think about what it takes to look at a person who loved you and decide they are a resource to be managed. I don't have a clean explanation for it. What I know is that the path from I need more money to "I will manufacture evidence of my father's incompetence" is not a short one. You don't make that journey in a single step. You make it in 100 small compromises, each one a little easier than the last, because the previous one didn't cost you anything visible. That is what I want people to hear. Not the courtroom, not the gavel. The 100 small compromises. That's where the real story lives. That's where you still have time to choose differently. Elaine used to say that character is just habit dressed up for company. I think she was right. My son's habits. The entitlement, the avoidance, the willingness to let his wife carry the weight of a scheme he didn't have the courage to run himself. Those didn't appear overnight. They were practiced. They were rehearsed in smaller rooms before they showed up in a courthouse. And my habits, the patience, the documentation, the refusal to act until I understood the full scope of the problem, those were practiced too. In 41 years of engineering, in 38 years of marriage to a woman who never once panicked when she could think instead, the land is still mine. Chester is asleep at my feet as I write this. The creek still runs the same direction. Some things you earn, some things you fight to keep. Both of those are worth doing.